So it is an enormous pleasure to be here with all of you. Our protagonists really don't need much of an introduction. And I'm very tempted to dispense with it, quite frankly, altogether. And with some permission, I will. Natalie and Christian, they're leading members of the New York and International Bar. They've both been in practice for decades. They both do investor state and commercial arbitration. They both represent investors and states. They do it all. And we know they're excellent advocates or they would not have been selected. And I want to thank you both for, I know what an investment of time, energy, well, and reputation. No pressure is involved. Nor need I introduce in any detail my tribunal. Lucy Reid, I've just gotten done telling her she's occupied every post in the world of international arbitration that one could like to occupy. So Lucy Reid is our chair. Charles Brower, who's paying a return visit, has the distinction of having been not only an active arbitration practitioner, initially at White & Case, but unlike many of us, a very active judicial role. Inter-American Human Rights Commission, and of course the Iran U.S. Claims Tribunal. So we have an august tribunal, present company excluded. And I am grateful to you all, and thank you for being our chair, Lucy. And as our chair, I invite you to convene us.
Thank you, Professor Bermann. We are now opening the oral argument in the case of Investor, not a very creative name, Investor versus the state of Corellia. As a point of order, may I ask, is Investor a woman, a man, or a legal entity?
That's a very good question. I think hopefully we'll discover. I think we will assume it's an individual.
All right. Thank you. Sometimes the tribunal likes to know these things. So the first issue is jurisdiction, and so I invite Respondents' Counsel, Natalie Reid, to be fully ethical. Natalie and I often say we would like to be real sisters, but we are not. There's no conflict of interest or bias whatsoever. Natalie, over to you.
Claimant had an opportunity to object and decided not to. Madam President, members of the tribunal, good evening. I have the privilege of appearing before you today on behalf of the state of Corellia. This evening, I will focus on two issues. First, why the tribunal lacks jurisdiction over investors' claim under the Alderaan-Corellia Treaty, and second, why investors' claim under Article 3.1 of the treaty fails on the merits. Before turning to the jurisdiction argument, let's take a step back so that we can put investors' claim and its attempt to invoke the protections of this treaty in its proper context. Since early 2020, Corellia, along with the rest of the galaxy, has faced the unprecedented horror of the Darth-19 pandemic. The pandemic is responsible for millions of deaths to date and continues to pose a grave threat to the health and safety of individuals throughout the galaxy, including Corellia's population. This ongoing threat to human life and health is the reason that Corellia prudently issued an executive order in March 2020 on the advice of its health experts to close its borders to all travelers other than Corellian citizens and permanent residents. In circumstances like these, where governments are focused on combating a public health crisis and on managing or attempting to avoid the economic crises that can ensue, the steps that are taken to minimize the distraction and expense of disputes take on particular importance. As such, the jurisdictional provisions in the treaty do not simply define key terms. They reflect the express, intentional, and considered decisions of the contracting states about which disputes they will arbitrate. Simply put, these provisions are a critical tool for these states to manage exposure to potential claims, and therefore already reflect a balance struck between encouraging investments and protecting the state's treasury. Those decisions by states can never be taken lightly, but in light of the burdens imposed by a galaxy-wide pandemic, the agreement between contracting states not to assume certain obligations must be respected. With these considerations in mind, we come to the jurisdictional questions before this tribunal. In this case, the claim must be dismissed for lack of jurisdiction on either of two independent grounds. First, the tribunal lacks jurisdiction because claimant is simply not a qualified investor as defined in Article 1.3 of this treaty. Second, the tribunal also lacks jurisdiction because the joint declaration between Alderaan and Karelia, amending Article 1.3 of the treaty, excludes claims brought by persons like investor who hold Bespian citizenship. So let's begin, as all good counsel should, with the text of the treaty. Article 1.3 defines investor as any natural person or legal entity that has made an investment in the territory of another contracting party, provided that, and this is key, provided that the natural person is not, on account of their nationality, able to avail themselves of investment protections under another international investment treaty. In other words, this provision says that an investor can only invoke this treaty if it is their only option for investment treaty protections. In this case, it is undisputed that investor had at least one other option. Investor is a dual national of both Alderaan and Bespian. Bespian has its own investment treaty with Karelia, and claimant could very well have invoked the protections of that treaty instead. For that reason alone, and on these undisputed facts, claimant cannot qualify as an investor under this treaty, and the case must be dismissed. Now, counsel for investor will likely argue that the Bespian-Karelia BIT bilateral investment treaty, of course, does not contain sufficient or adequate protections. But that argument ignores the actual text of this treaty and the object and purpose of these provisions. The Alderaan-Karelia BIT does not state that the other treaty that is available to the investor must provide adequate, equivalent, or even substantially similar investment protections. In fact, it makes no comparative or qualitative assessment at all. It simply says that if a person can avail themselves of investment protections under another treaty, they cannot invoke this treaty. The plain meaning is clear. If there are any protections available elsewhere, there is no jurisdiction here. Accepting the interpretation that investor has advanced throughout this case would require this tribunal to read in words and guarantees that the contracting states could have inserted, but decided not to. As to object and purpose, claimant asks this tribunal to view the Alderaan-Karelia Treaty as simply one in a menu of options, in which an investor, like a diner at a restaurant, can pick and choose which they might prefer according to their own tastes, or in this case, their own strategic litigation decisions. But that is not what the contracting states intended. Instead, we know from the record that Alderaan and Karelia expressly designed this bilateral investment treaty to minimize investment disputes between their states to the extent possible. That is the purpose behind the definition of investor in Article 1.3. It is a safety net, not a port of first call, and not an option on a menu. The second and independent reason that this tribunal lacks jurisdiction is as a consequence of the March 2021 joint declaration between Alderaan and Karelia. That declaration amends the treaty by inserting Article 1.3a and clarifying that, quote, any person who holds Bespian citizenship is precluded from bringing a claim under this instrument. As we have stated, it is undisputed that investor holds Bespian citizenship. As a result, and under the plain terms of the treaty, investor cannot bring a claim under this treaty. Importantly, the fact that the joint declaration was issued 2 months after investor brought its claim, March 2021, after investor brought its claim in January 2021, does not alter the conclusion that there is no jurisdiction here. First, this is not about retroactive application of a substantive treaty obligation, such as might, in theory, fall afoul of the so-called presumption of non-retroactivity. The issue here is the scope of the tribunal's jurisdiction, and tribunals have repeatedly recognized that the scope of jurisdictional provisions is a question separate from the retroactivity of substantive provisions. And there I quote the Ping An versus Belgium Tribunal. Likewise,
Counsel, may I pose a question?
please.
The standard here, on your first point, is whether claimant was able to avail itself, of investment protections under another treaty. Do we know that merely because there is a Bermann-Praelium treaty that the claimant could have, let's get the words, availed itself of that treaty, don't we need to make some inquiry into nationality and the test about dual nationals?
What we know from the record, Professor Bermann, is that investor is a dual national of Alderaan and of Bespin. There is no dispute about that.
Right.
We also know that all three states have bilateral investment treaties among themselves. So we know that there is a Bespin-Praelium treaty. In the discussion, in the submissions of the parties, we also know that claimant has explained its choice of this treaty by saying that this treaty, as in the Alderaan-Praelium treaty, essentially has better substantive protections than the treaty that applies between Bespin and
I'm only
Praelium.
concerned about whether we're confident enough that Bespin would be able to avail itself. Because I don't know what the nationality criteria are going to be.
Or what if there's also 1-3 in that other treaty?
We have not
And we've got renvoi.
We have not heard otherwise from claimant to date, certainly. I will be intrigued if claimant's counsel introduces this argument at the last moment. What we do know in terms of the arguments that have been developed based on the record is that the arguments that investor has advanced for why it should be allowed to proceed with its claims here have in no way asserted that it could not bring its claims under the Bespin Treaty.
Okay, so you're, in a sense, they bear the burden.
They do bear the
They bear
burden.
the burden of establishing that they cannot avail themselves.
Absolutely correct. They bear the burden as the claimant, first of all, of establishing that the tribunal has jurisdiction. And when respondent, as here, has asserted a well-founded jurisdictional objection, claimant does bear the burden of persuading the tribunal that it does have jurisdiction. And in this case, we will argue, as we have demonstrated, they can't meet that burden.
Okay, I don't want to detain you, but I think they would have to tell us something about whether this claim could be pursued under that other treaty, which depends on the nationality question. But we can't know what a tribunal under that other treaty is going to do with respect to dual nationals. So I don't think there's much you or I can do about this.
What I would say, Professor Bermann, is that the tribunal, of course, has to reach its decision on the record in front of it. It would have been claimant's obligation, returning to that burden, to supplement the record, to allow the tribunal to reach any contrary decision. On the record before you and the undisputed facts, Praelium's submission is that there is only one conclusion, and that is that the tribunal lacks jurisdiction.
Thank you, counsel. That was helpful.
Excuse me, but you're, actually, one would require application of Article 31 of the Vienna Convention on the Law of Treaties to interpret the treaty that you're proceeding under, and that apparently you say, well, that's not been done by the other side. Is that your point?
My point is that under the classic rules of procedure that are applied by tribunals interpreting investment treaties, that it is the burden of the party that is asserting jurisdiction
Right.
to persuade the tribunal, including by applying the classic rules of interpretation of treaties. Correct. So if part of the argument had been that it had no other option, that is an argument that is suggested by the plain text of Article 1.3. It would have been up to claimant to, first of all, provide the tribunal with the factual basis, and then, yes, to make the classic Vienna Convention argument, construing the terms of both this treaty and that treaty in order to substantiate its assertion that it can only bring its claims here.
I have two other questions.
But her time is up.
Is my time up?
This is why they have a woman.
They're very short,
She
very,
She will have rebuttal. You'll have rebuttal. We'll have more questions for you on rebuttal. Could you finish up your argument in 30 seconds, please?
I will indeed. The second and independent reason, just to make sure that the tribunal has both of these grounds in mind, that the tribunal lacks jurisdiction, is that the March 2021 joint declaration between both of the contracting states, including one of the states under which investor, of course, holds nationality, amended the treaty and inserted this text, that any person who holds Bespian citizenship is precluded from bringing a claim under the instrument. That text clarifies the existing text that we had in Article 1.3, and again, in light of the undisputed facts here, that investor holds Bespian citizenship, means that they, investor, cannot bring a claim under this treaty before this tribunal.
Thank you, Ms. Reid.
Thank you very much.
Thank you.
Mr. Leathley for the claimant, please.
Thank you very much, members of the tribunal. I feel we should bring some ice to cool this hot bench somewhat. I'm very grateful to have the opportunity to present investors' closing submissions. And the question before you is whether you have jurisdiction over investors' claims under Article 1.3 of the Alderaan-Karelia BIT, taking into account the joint declaration of March 2021. And the short answer is yes, you do. Article 1.3 is no bar to investors' claims, and Article 1.3a, the joint declaration between Alderaan and Karelia, does not even apply to this dispute. Now, Council has kindly read into the record Article 1.3, and I'd like to emphasize the words I would ask you to underline, which is able to avail themselves. Respondent has described this as a complete bar to investors' claim, because investor is a national of Bespin, that's undisputed, and there exists a Bespin Karelia BIT, also undisputed. But respondent doesn't carefully consider the text of Article 1.3, and that's something I would invite you to do. Article 1.3 only bars jurisdiction where an investor is able to avail themselves of investment protection under another international investment treaty. And I'll explain how Article 31 of the Vienna Convention informs your good faith interpretation of Article 1.3. I'll consider the object and purpose of Article 1.3, and I'll explain how you should sequence your decision making. And I'll also look at Article 1.3a, that's the joint declaration. This is the very provision that state wants you to give effect to, but it is the very provision that compromises state's interpretation of Article 1.3. First, let's start with the text. The treaty terms must be given their ordinary meaning. The ordinary meaning of the words able to avail themselves means able to take advantage of, to receive the benefit of. But receive the benefit of what? Well, respondent argued that it should be construed to mean to receive the benefit of any investment protection. That interpretation fails the proper textual analysis, and you should focus on what relief investor is able to avail itself of under the Bespian Karelia BIT. Well, we know for a fact that the investor has raised the claim of FET. And so now you face one major distinction that respondent has sidelined to some extent, which is that investor is not able to avail itself of FET protection under the Bespian Karelia BIT, because we know for a fact that that BIT does not contain FET protection. We also know it doesn't contain an MFN provision. So how do you navigate this textual analysis and give effect to the ordinary meaning of Article 1.3? Well, the answer is in the sequencing of questions that you must ask yourselves. The starting point is not to search for other bits, and when you find one, ask, does it contain some kind of investment protection? And if it does, then feel satisfied that it triggers Article 1.3. No. The starting point is more logical and sequenced. Your first step is to look at the subject of Article 1.3, and that's my client, investor. The reason you look at my client is because it is bringing the claim and wants to avail itself of the protection afforded under this Alderan Carelia BIT from this arbitral tribunal. Therefore, the next step in your inquiry is what protection, if any, is investor availing itself of? The answer here includes FET. Then with those foundational elements at your disposal, you read Article 1.3 and ask, is that FET protection something that investor is available to avail itself of in another bid?
Counsel, I'm having a trouble with your interpretation of Article 1.3. It says, is the claimant able to avail themselves of investment protections without any specificity? Is there any doubt that claimant could avail itself of investment protection?
Well, so we would say that you have to separate out the types of investment protection. Each cause of action would
Well, where
raise...
do you see that in here? I'm just seeing investment protections without any specification. It almost seems to me as if the word any were in it. Now, you may tell me they didn't put the word any in it, therefore, but isn't the plain meaning of able to avail themselves of investment protections means able to avail themselves of some investment protections?
No,
Does
sir.
it have to be identical?
No, sir. But it is not a de minimis requirement where so long as you have one protection, that satisfies all. The fact goes to and this enters into my second argument, that the purpose of this provision is to avoid duplicative claims. There would be no duplicative FET claim. Therefore, the tribunal would be killing a claim that would not exist under the other treaty. That would deny precisely the purpose of what Article 1.3 was set up to achieve. We know that that's part of the purpose because in the materials before you, it says that part of the purpose was to not only incentivize investment of that BIT, but also we know that it was to minimize investment disputes between their states, as Alderan and Carelia, to the extent possible. And by its very functioning, Article 1.3 seeks to reduce duplicative claims. So that goes in part, if I may say, to the second argument. Yes?
Crowder, this time.
Oh, thank you. Beginning to feel like I'm in class at Columbia Law School.
Not because of
There is an anomaly in Article 1.3, which says, with regard to either contracting party, any natural person or legal entity that has made an investment in the territory of another contracting provider, that's the definition of investor, provided that the natural person is not on account of their nationality able to avail themselves of investment protections, and so on and so forth. Now, there seems, if this were subject to the United States Constitution, there would be a discrimination or some of our laws. This is very strange, but I think both parties must take the position that only a natural person can be a dual national of two different countries, and therefore that's what we're dealing with here. Very strange. Go ahead.
Yes, sir. No, we would concede that investor is a natural person and is a dual national of both Bermann and Alderan. Let me move on to my third argument, having dealt very briefly in response to your question about the object and purpose of Article 1.3. And this brings me to Article 1.3a. Article 1.3a provides, and I read, any person who holds Bermann citizenship is precluded from bringing a claim under this instrument. That's the Alderan Carelia bit. Now, You heard State argue in her opening words that this catches my client like a double whammy. First Article 1.3 and then Article 1.3a. But on State's reading of Article 1.3, my client already doesn't have jurisdiction by virtue of Article 1.3. Therefore, why did the State introduce Article 1.3a? If something has to be said twice, it means it hasn't been said properly the first time. And if investor was already effectively barred by respondents' broad interpretation of Article 1.3, Article 1.3a serves absolutely no purpose. That would be something that the Vienna Convention would be offended by, the redundancy of that provision.
Excuse me, I think you're running up against the problem that you're referring to the joint declaration,
Yes,
right?
sir.
First of all, is there indication that that joint declaration by the two parties entered into force?
It's not disputed, sir, that the joint declaration did form an effective part of the BIT as Article 1.3a.
All right? Okay. go
Thank
ahead.
you. And so let me, if I may, return finally to my what would be a few closing remarks in relation to Article 1.3a. It's important that we do the date check that my colleague was kind enough to draw to your attention as well. Article 1.3a entered into force after March 2021. This means it entered into force after the date of the dispute and after the date of our claim. And that is an important issue. There is no language indicating that it is to have retrospective effect, and absent such language, we would say Article 28 of the Vienna Convention should police against that effect. Also, it's clear, we would say, on the ordinary meaning of Article 1.3a, that it does not apply to investors' claim. It refers to precluded from bringing a claim. This is drafted in the present tense and applies to new claims that will be brought in the future. If this were to apply to past claims, it would have been worded differently. And finally, Article 1.3a is essentially a denial of benefits clause. Tribunals are very careful to make sure that a denial of benefits clause does not operate retroactively to deny an investor of its rights that it believed it had when it entered into its investment. I have nothing further at this stage on jurisdiction. Thank you for the tribunal's time.
Thank you, Mr. Leathley. Ms. Reid, you have 5 minutes for rebuttal.
5 minutes, and quite a lot of ground to cover. Thank you very much, Madam President. It is important to pay attention to what investor does not dispute. Investor does not dispute that there is another treaty. Investor, to answer the questions that Professor Bermann raised, has never contended that this treaty is not available to it. Again, the arguments that investor has asserted refer to the quality of the protections that are available. Mr. Leathley, claimant's counsel, wants you, the tribunal, to start in the middle of the analysis. According to him, you should focus on what claimant wants as opposed to what the treaty provides. It says that you shouldn't consider what other treaties are out there, but that is precisely the analysis that this treaty directs you to conduct. A natural person, picking up on Arbitrator Brouwer's point, cannot invoke this treaty if they can avail themselves of investment protections. And as Professor Bermann noted, there are no qualifications. It does not say the same. It does not say equivalent. It does not say as good as. It just says investment protections. The purpose of this provision is not to avoid duplicative claims, as claimant's counsel asserted. That language, avoiding duplicative claims, appears nowhere in the record. What we have instead in the record, and the language actually in travaux, is minimizing disputes. And we know minimizing disputes under the terms of Article 1.3 is focused on nationals that could have another treaty. Dual nationals, like investor, are the prototypical kind of claimant that this treaty says cannot invoke these claims. On the question of the temporal application of Article 1.3a, claimant's counsel asserted that Article 1.3a has to be read together with Article 1.3, and that Corellia's reading of Article 1.3 makes no sense because Article 13A would be redundant. It would have no purpose. Carelia submits, as we had noted in our opening submissions, that Article 13A is merely, as we see in investment treaties and indeed investment contracts around the world, a belts and braces provision. It's a belts and suspenders provision. If you had any doubt about whether Bespian investors could assert these claims under this treaty, Article 13A says that it cannot, that the investor here cannot. And it is not a denial of benefits provision. It is important to note this is not a provision that is targeted at the investor here, that seeks to deny this specific investor the ability to proceed on its claims. The record here tells us that the reason that both of these contracting states, again, including one of the home states of investor, fully aware that investor had already brought these claims, the reason that they made the joint declaration and amended the treaty was because of security concerns after the regime change in Bespin. That is the reason for Article 13A, and it provides an independent ground, separate and independent.
Counsel, that's consistent with what you just said, I think, which is that it was belts and braces. For you to say there was a separate motivation. Are there any circumstances you can tell us where an investor would have qualified as an investor under the article, given the existence of the other bits?
Investor could not have qualified as an investor, the investor here. We, of course, have the complication that we do not know the full name of investor. They would not have qualified as an investor under Article 13, so which is why in Carelia's submission, these are two separate and independent grounds. The point that I was making about whether or not this is the equivalent to a denial of benefits provision goes to the motivation of the states in making the joint declaration and in specifying why Bespin nationals in particular should not be able to invoke this treaty.
I think it is more than belt and braces, but I understand.
Thank you very much, Madam President. If there are no further questions?
Judge Brower, now's your chance. Would you
I've
like?
asked my questions.
All right. Thank you.
Thank you very much, members of the tribunal.
Now we move, and thank you both. Now we move to the second argument, in which goes to the more to the merits, the substantive protections, and we'll hear first from you, Mr. Leathley, for 10 minutes.
Thank you very much, Madam President. Members of the Tribunal, I'd like to present our closing submissions on merits, and I would touch briefly on the facts, if I may, and be given perhaps 60 seconds to do so. Investor has suffered significant harm at the hands of the state. It has had its factory seized by the Praelium police officers, claiming that its products were deliberately breaching security laws, and investor has denied this. Also, investor has been denied proper and due access to defend its investment before the state authorities. And as part of the state's conduct, and during the DART-19 pandemic, state closed all of its borders and refused entry to all travelers other than Karelian citizens and permanent residents. Now, this was in breach of the obligations owed by state under the Alderaan Karelia BIT. And in this instance, I'm only going to refer to the BIT because it's going to be the one treaty that we're going to be referring to. Now, in order to close the country's borders, the Karelian government issued an executive order. In January 2021, investor brought a claim against Karelia under the BIT, alleging various claims, and you've asked us to summarize our positions on whether the executive order violated Article 3.1 of the BIT. Now, Article 3.1 provides, and it's titled The Entry and Sojourn of Personnel, that each party shall, subject to its laws applicable from time to time relating to the entry and sojourn of non-citizens, permit natural persons who are investors of the other party and personnel employed by companies of that other party to enter and remain in its territory for the purpose of engaging in activities connected with investments. Now, before I take you through our interpretation of this provision, it's worth pausing and reflecting on this article from a high level. This is broad. It's empowering and an essential protection for not only investor, but personnel employed by investor. It's also broad in its scope, given it talks about the purpose of engaging in activities connected with investments. This is unspecific because it's granting a freedom to do business and for the benefit of investments based in Carelia. Now, Counsel for State is going to tell you that Article 3.1 is simply a button to be pressed, allowing the borders to be closed in precisely these circumstances. And they will point to the subject to language in Article 3.1 and say that the executive order is such a law, case closed, you will hear. Now, that superficial interpretation of Article 3.1 would do a disservice to what the contracting parties agreed. Article 3.1 must be interpreted in good faith and in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose. Article 31 of the Vienna Convention directs us in that regard. Now, the reference in Article 3.1, the subject to language, does not modify states' obligation to permit investors to enter and remain. It simply makes clear that an investor's right to remain is still subject to applicable laws when it enters or sojourns. In Carelia, for example, complying with customs laws, criminal laws, and the like. So Article 3.1 upholds the most basic of rights provided to qualifying investors from Alderaan, such as my client, which is that if they have an investment in Carelia, they and their personnel be allowed to enter and tend to that investment. Otherwise, by simply referring, or simply interpreting rather, the executive order as a legitimate applicable law, that satisfies the subject to qualification, you would deny investor access to its investment and would allow a backdoor route to the undermining of the protection and the integrity of that investment. Now, ironically, that's exactly what happened in this instance, and the exception should not readily consume the rule. If you interpret this exception in a broad manner, you would subordinate a right afforded by international law to the executive orders issued on the domestic law plane. Now, the BIT has the object and purpose, we're told, to incentivize investments. And the BIT also includes various protections, FET, non-discrimination, expropriation, and the like. And it must be interpreted in that context. Therefore, the focus and the purpose of Article 3.1 is not the subject to exception, but the need to allow the investor and its personnel to enter and remain in Carelia.
Even if there are risks to the public.
I will come on to the balancing act, Madam President, in a moment.
Before you do that, but related to it, I don't know what we're going to hear from the state, but the rationale for this is espionage risk, sensitive sectors such as defense. You'll have an opportunity, I think, if that is raised as a defense, to address it in your rebuttal. So I just want to put you on notice that I would be.
Very good, sir. Thank you. I would say, returning to Article 3.1, that Article 3.1 anticipates precisely this scenario that you're faced with today and reflects the contracting party's agreement that an investor not be denied the practical means of remaining in Carelia for the purpose of engaging in activities connected with its investment. Now, even if you were inclined to test whether the executive order could override the very substance and protection afforded in Article 3.1, respectfully, we say your task is not to assess whether that executive order has been passed in accordance with Carelian law. Your task is to assess it in relation to international law. And the regulatory framework at the time of the investment, which under Article 3.1 ensured that investor would be allowed to enter and remain in Carelia, was drastically altered by the executive order. And it caused extensive damage as a result. The executive order completely prevents investors for an undetermined period, potentially forever, from entering Carelia, and it leaves them with no recourse to manage, protect, or even police in person the persecution of their investments which the facts tell you is a very relevant impediment. Now, this executive order is essentially the thin end of the wedge, a wedge that has driven a huge divide between investor and its investment. That executive order, therefore, has decoupled precisely what the BIT seeks to protect and promote, investors and their investments. And if you allow a state to decouple the most basic construct, and you allow an investor to be separated from its investment, then the entire purpose of the BIT is undermined. Now, even though the executive order tried to ensure social well-being in the circumstances, it doesn't meet the basic requirements under international law. It was arbitrary and discriminatory, unreasonable and disproportionate. Now, the Darth-19 pandemic does not discriminate between citizens and non-citizens. And while Carillion nationals and permanent residents can come and go as they please, qualifying investors and their foreign personnel are completely banned from entering the state without exceptions. Now, we're acutely aware of the horrors of Darth-19, and we're very sensitive to the human impact and the public health concerns that motivated the executive order. But the executive order was framed in an arbitrary way. Rather than a complete and unconditional closing of the borders, not letting anyone in or out, the borders remained open to Carillion citizens and permanent residents. That means a residency and citizenship status was applied as a basis for the exception to a total ban. Granted, a state has an obligation to allow its citizens to re-enter, but here the exception went beyond just citizens and allowed permanent residents to also re-enter Carillia. Now, the rationale for the exception to a total ban was therefore presumably to permit certain movement of people, to allow them to return to their homes, their welfare, and most likely their jobs and their source of income. Therefore, isn't it safe to assume that integral to the qualification in the executive order, that is, regarding citizens and permanent residents, there was also a consideration of economic factors? And that is what we're asking you to consider, that how arbitrary this executive order is. Because why should economic factors feed into allowing citizens and permanent residents to return to Carillia, notwithstanding the risk of the spread of Darth-19, and yet not allow proportionate qualifications for those who qualify as investors under the BIT?
Councillor, your time is up. Or rebuttal remarks.
No, thank you very much. Let me leave it there.
Thank you. Ms. Reid for the state, 10 minutes.
Thank you very much, Madam President. Carillia's case on the merits is simple. The executive order does not breach Article 3.1. To respond to Professor Bermann's question, the question here isn't whether the state's action with regard to the factory breaches any provision of the treaty, but rather whether the executive order closing the borders breaches Article 3.1. It did not. In the alternative, even if it did breach Article 3.1, the state's conduct here would be saved by the well-established doctrines of police powers and necessity. So let's begin with no breach. The executive order is an order of general application. It applies to all persons who are not citizens or permanent residents of Carillia, and it protects human life and human health. It is not discriminatory, it is not unfair or inequitable, and it is in no way internationally wrongful. Article 3.1, a largely standard form entry and sojourn provision found in many treaties across the galaxy, confers on an investor a contingent right to enter and remain in Carillia for the purpose of engaging in activities connected with investments. It does not, as investor would have it, confer an unqualified and unencumbered right to enter Carillia at any time. On the contrary, the article expressly provides, as Claimant's Counsel was forced to acknowledge, that the right to enter is subject to the laws applicable from time to time relating to the entry and sojourn of non-citizens. The treaty means what it says. There is no absolute right. It is subject to these laws. Now, the executive order is a law that is applicable from the time to time relating to the entry and sojourn of non-citizens. Now, it makes perfect sense, of course, that the treaty expressly makes this right of entry subject to the state's prerogative to make such laws. Regulating who enters its territory, on what terms, on what conditions, and when, is one of the most fundamental aspects of state sovereignty. Now, it does not matter, contrary to claimants' counsel arguments, that permanent residents of Karelia, that is, some non-citizens, can also enter the order. The order is still, even though it draws the line of distinction at a different place than claimant would have it drawn, it is still a law relating to the entry and sojourn of non-citizens. It says that certain non-citizens, i.e. those who do not have permanent residency in Karelia, may not enter. And that decision to admit permanent residents may well reflect a state's balancing and reconciliation of different obligations, including those it may have under domestic and international law regarding the right of permanent residents to enter. Now, finally, again, it's important to recognize and remember the context in which all of this is happening. It would wreak havoc across this galaxy at a time when almost all states have found it necessary at one time or another, as part of attempts to curtail the pandemic, to restrict entry to persons generally, or to persons from specific countries, for this tribunal to find that such prudent measures are internationally wrongful under an entry and sojourn provision that is framed in these terms. It is not. But, in the alternative, even if the tribunal were to conclude that the executive order does contravene the text of Article 3.1, it should also conclude that there is no liability because the order is a legitimate exercise of Karelia's police powers. Now, the test typically applied under this doctrine is 4 criteria, as summarized by the Servier Tribunal. First, the measure must have been taken in good faith. Second, it must be for a public purpose. Third, it must be proportional to that purpose, a point on which claimants' counsel spent quite some time. And finally, the measure must have been taken in a non-discriminatory manner. The order satisfies each and every one of these criteria. First, there can be no serious dispute that the executive order was taken in good faith. The measure was taken on the advice of public health experts and with the aim of responding to and attempting to curtail the spread of the DARth-19 virus. Second, there can be no real dispute that the order was taken for a public purpose. That purpose was to protect the life and health of Karelia's population. For more than a century, international tribunals have repeatedly recognizing and preserved the ability of states to issue such health-related regulations. We can go back as far as the 1908 Bischoff case, in which the Mixed Claims Commission held that the seizure of a German carriage by Venezuelan authorities after it had carried 2 people infected with chickenpox across the border did not constitute a wrongful taking under international law. In terms that should resonate today, the Commission held, and I quote, "Certainly, during an epidemic of an infectious disease, there can be no liability for the reasonable exercise of police power, even if a mistake is made." That recognition, of course, that recognition of the primary duty that is imposed on a state in these circumstances has been recognized by tribunals, of course, much closer in time, including the Philip Morris Tribunal and Chemtura versus Canada Tribunal. On the third criterion, the executive order was proportional. And again, the test here is about whether there's a reasonable relationship of proportionality between the burden that is supposedly imposed on the investor and the aim that is sought to be realized. In closing Karelia's borders to all travelers, other than its citizens and its permanent residents, what Karelia did, that order, is reasonably linked to the stated aim, preventing the spread of the variant. It is therefore proportionate to the aim it hopes to achieve.
Counsel, what about the claimant's argument, which we didn't have time to cover in a few moments, about not having access to a communication channel to try to protect his property after the borders were closed? Would it not be obligatory on the state to provide some method of protection? Just as this tribunal, I mean, we could just say, well, we're not going to have a hearing because DARth-19 ever too bad. Instead, there's an understanding we can find some alternative avenue for your legal rights and protection. That's a part of proportionality, I would argue.
That-
Another aspect of proportionality is it says indefinitely. I don't think any country in this world has barred because of an ongoing academic or ever do it periodically. We don't know that it ever ends.
If I could take those points in turn, members of the tribunal. First, for Madam President, it might have an impact if that actually were part of the factual record. What the record here tells us is that the limitation on claimant's ability to communicate with those in Karelia was that claimant could not participate in video conferences or other methods of communication with the Karelian authorities with regard to the seizure, the closure of its factory. There is nothing in the record to establish, and in fact, we can represent on behalf of Karelia, that claimant had there was no barrier on claimant communicating with counsel or any other agent that could have been appointed to represent and advance its interests in Karelia. There's nothing in the record that would say that any Karelian permanent resident or citizen, for example, who works in claimants' offices or other methods of representation would have been prevented from pursuing and implementing any instructions that claimant got. The only limitation on communication is unfortunately that the Karelian authorities have too old a copy of Zoom.
So you wouldn't concede that there would be some obligation on the part of the state for fair and equitable treatment, or procedural treatment to help?
To follow up on that, proportionality, the principle requires at least some consideration of less drastic means. Now, that was implicit in some of the questions you've heard, but have you considered less drastic means?
What we know from the record, and this in some ways overlaps with the necessity doctrine, which we had asserted and as fully set out in our papers, is also an independent ground for concluding that there is no liability, is that at the time the executive order was imposed, again, if you recall, this is the onset of the pandemic in March 2020, there was no more effective and less restrictive means of preventing the spread of the disease. At the time, closing the border and limiting those who can move across the border and therefore be additional vectors of the disease was the only way to effectively safeguard the health of Karelia's population. Other restrictive measures, if we think about restricting arrivals to quarantine, for example, we have seen, and painful experience has shown, is not as effective in stopping the spread and is exceptionally difficult to manage and maintain.
1 minute.
So then, to summarize, there are 3 independent grounds on which the tribunal should reject investors' claim on the merits and conclude that Karelia bears no liability under Article 3.1 of the treaty. Number 1, there is no breach of Article 3.1 on its terms because the executive order is precisely the kind of law that is the exception to any right to enter that investor may have. Number 2, even if there is a breach, the police powers doctrine provides a full defense and there would be no liability. And number 3, even if the police powers doctrine is not acceptable to the tribunal, the necessity doctrine, which again precisely balances these different considerations, and to which tribunals have deferred to the proportionality and reasonableness judgment of states, also provides a full defense. Thank you very much.
Just one question. I haven't heard you would raise the question of possible national security stakes here. Is that absent? No? It seems to me the facts, as I understand it, raise those kinds of issues.
Those underlie some of the facts, Professor Bermann, but they are not put directly at issue by the argument here.
Yeah.
They're relevant to jurisdiction and they're relevant to the underlying state action in seizing the factory. But they are not, the question is whether the executive order, the closing of the borders, is itself a violation of Article 3.1.
Thank you.
Thank you very much.
Mr. Leathley, Bodo.
Thank you very much. I'd like to pick up from where Professor Bermann's question left us with my colleague, which is the question of the espionage. And let me respond to the 4-prong test that Ms. Reid set out, the first being good faith. We have no reason to believe that there is a lack of good faith in wanting to protect the Carillion population from the effects of the DART-19 pandemic, except for the fact that there are clearly, and your record has it, desires to counter certain espionage activities. And now, of course, Article 3.1 is being invoked by the state as a means of keeping certain foreign nationals out. I would simply leave that as an unanswered question rather than wholeheartedly endorsing and admitting that there is good faith here. But let me look at the public purpose. We believe that, of course, there is a public purpose to the executive order. The question is whether it's being effectively or arbitrarily exercised. No public policy ruling can stand isolated from economic persuasions that obviously inform public purpose, and expecting to take economic considerations out of the factoring in of legitimate public policy considerations in a public health dilemma is like trying to take the egg out of a baked cake. It's simply not possible. The concerns for human health go hand in hand with economic sensitivities. So the public purpose, yes, is being served, but it also has to serve the economic sensitivities. Now, we have no idea. There could be millions of Carillion nationals and permanent residents crossing the border. So the executive order is not motivated by headcount. Therefore, the investor that is being denied entry, one investor, of course, could be also one of many, does not leave that as a distinguishing feature to support the public health purpose of the executive order. That is where we say it is arbitrarily drawing the line around a group rather than necessarily a number of people. We would also disagree with the third prong from Ms. Reid that it is not proportional. It was not a proportional means to deal with the public policy objective because it didn't allow for any avenues for the investor to somehow enter Carillia. There was no health screening suggested, no testing, no quarantining, and there are other means, as we know, to work around the problem. Instead, Carillia simply pulled up the drawbridge and said, no more entry forever. And we would underscore the point raised as a question by Judge Brower. Indefinitely is exactly how the executive order is structured. The executive order essentially violates the most basic tenets of international law that Article 3.1 is imbued with. Article 3.1, again, to reorient the tribunal, Article 3.1 is an empowering provision. It is not saying you can overrule me by simply introducing a piece of domestic legislation. It is saying I'm here to protect and hold the door open to investors. Now, we also heard about the consideration, non-discriminatory treatment. I think I've already dealt with that to some extent in my earlier remarks, that this is obviously a discriminatory treatment, not based on headcount, but based on nationality. And so then if I may, just dealing with the consideration of the drastic measures that were taken, I think, Professor Bermann, that was your question. Yes, less drastic measures could have been taken. For example, if Article 3.1 was to be read and deconstructed somewhat, there are personnel that perhaps could have been subjected to the executive order, but not the investor. That would at least have allowed the investor to return and tend to the investment. And then in terms of the police powers and the question of necessity, of course, we understand the public health imperative that Philip Morris underscores, and the Bischoff case, the 1903 case that integrated as part of its decision. But there are obviously counter-authorities for you to bear in mind. Santa Elena, where, of course, the tribunal ruled that compensation can still be something that can be ruled, even in circumstances where public health imperatives are being protected. And that's something we would invite you to take consideration of. And then finally, with necessity, well, necessity really requires you to have a conclusion that this is the only way. And I think we can be safely concluding that this is not the only way that Carillia could manage its border. Thank you.
Can you finish? Can you summarize into one sentence, two sentences, your argument on why the executive order violates right to?
Thank you. For two reasons, if I may. The first, Article 3.1 I would ask you to put the subject to language in a parenthetical, and that is merely a standard of performance already in accordance with national laws. That is to say, Article 3.1 is an empowering provision that holds the door open for investor, and the subject to language is merely meant to state perhaps even the obvious, but simply provide a dynamic reference to what the laws may be at any given time. And the other is that if you don't agree with that interpretation, exactly. The other interpretation would be if you concede, if you were to concede and look to the state's interpretation and think that the executive order can be exactly that, subject to applicable law, then we would say that it still violates standards of international law because it's discriminatory, disproportionate, and arbitrary.
Thank you.
Thank you.
So we thank counsel for both parties, and now, as I understand it, we're going to deliberate. Oh, okay. Yes, we have a few minutes to have our reactions, and then the advocates' reactions to what we all just heard. So, Judge Brower.
Do we retire? Are we?
No.
No.
To the
Oh my
to the
God.
wine, we could, but we better stay.
I think overall, Councillor Leathley had a tough case to. On
Mark?
both.
Well, I want to distinguish the jurisdictional issue from the merits issue. I think Christian Leathley had a harder time on the merits than he did on the jurisdictional issue. Well, actually, I want to go back to that interpretation of investment protections. I'm having a hard time. I had a hard time with the interpretation of the term. This is for you, Christian. It says
aware.
investment protection. I'm having a really hard time saying that unless it's identical. There are, it doesn't apply.
May I raise a question then? Wouldn't you agree that your jurisdiction can depend on the cause of action?
But it doesn't say that. It says
No,
avail-
it says a matter of international law. Could you find jurisdiction for some claims and not others?
Yes, of course you could.
So why would you not pass out types of protection being
Well, because
received?
I'm doing some plain meaning reading here, and I'm reading able to avail themselves of investment protections, and I think that means what it says. Protections is undefined, it's unlimited. So, on that jurisdictional issue, there we go.
So you would decide what, if you had to, on jurisdiction?
I would decide that there is, the alternative is available, and then, under this, the consequence. Jurisdiction is there.
Had you thought about making use of the MFN argument? No? Okay. Okay, understood.
Maybe-
On the merits point, do you want to go to merits?
But why is jurisdiction there? I would say jurisdiction is not there,
Well,
because there's
I mean,
access to the other treaty.
when I said that, I meant jurisdictional
Oh, okay.
issue. There is the jurisdictional
Right.
issue. And I think that's wrong. You want to get to the merits?
Well, I was just going to say, on jurisdiction, it's a tricky scenario. It's a very short scenario, obviously, but the joint declaration saying you weren't going to get to use this treaty, and now you really can't get to use this treaty, smacks of just outright discrimination for good public purpose, I think, given the minimal facts that we have. But that made the argument very hard, and I thought Christian's point was very well said about if you say something twice, you probably didn't say it right the first time, and there was a suggestion of some avenue for jurisdiction before 3.1a.
I suppose the question I would have
One,
as the advocate and one of the people who came up with the idea, but I should give credit to my colleagues as well who assisted with the provenance of the facts that Christian had to deal with. Did it bother you that Article 1.3a had been sort of added to the treaty? Because in kind of crafting the argument, I thought as you could tell, I thought I really had to kind of stand on, these are two independent grounds. Like, if you don't like one, you still have the other. I got caught up in that a little bit in the rebuttal, but I was worried that Article 1.3a would just feel bad to you.
Well, it does.
It feels bad.
It
Especially
does.
after taking over the factory.
And there is that retroactivity angle that I think is to be taken seriously. This has suddenly appeared. The investment was made long ago. To me, that was a problem. I don't know if others shared that, but it didn't sit well with me that this was just out there, just laid out there, despite the reliance that may have been placed on the treaty.
They couldn't dress it up as an interpretation.
Yeah, I was trying to
own
kind of
problems.
walk that line. I don't think I did it particularly effectively.
But it's interesting because it could have pressed on saying there wasn't any jurisdiction before the declaration. There's still that other treaty that they have access to. But by adding that fact, which is smacking of
Bad faith.
bad faith, it colors certainly how I thought about the other facts and the merits and what was happening overall, which is in the mind of a tribunal anyway. Obviously, we didn't have time to get to the real FET arguments, but as well argued as possible.
I do too.
Thank you. George, merits.
Hugh, can we, do you want to get to the merits now?
Yeah, we have time in the schedule, and then
Yeah.
the audience can ask questions. So,
Okay, well, for me, I'm just a proportionality guy, as people in the room know. So, I would have gone, if I had more license to question.
More than you took.
Yes, even more than I took. I would have pressed both of you on that. I actually do think there were less drastic means. You didn't have an opportunity, to convince me that these were the least drastic means. I think you would have had difficulty in doing so, because I can imagine, as the chair has, a large number of things that could have been done to mitigate the barrier that you erected.
I thought the most effective argument, which thankfully I didn't have to respond to, was, what do you mean, that you put up this barrier in order to prevent the spread of a disease and then let an untold number of permanent residents and citizens come back in?
Yeah, you
There's-
didn't
there-
make that.
Yeah,
That was
Only on rebuttal.
Yeah, only on rebuttal, yeah.
Because I ran out
But
of
it was
time.
made. Although one could distinguish a permanent resident, I think, from third country nationals.
completely. And
We do assimilate them to nationals to a very significant extent.
agreed. And again, there is this, and I tried to invoke that, look, a state has obligations towards its citizens and its permanent residents. That's a reasonable basis
I
on
think
which to
that's right.
distinguish, not discriminate. But I think Christian's point was, okay, but the whole necessity thing, like, if you're saying that this is the only way that you could prevent the spread,
Well, I think you could balance it differently. You could balance it differently for nationals, for permanent residents, and for non-nationals.
as somebody who has traveled back and forth to Jamaica many times during this pandemic,
Yes.
I can tell you that line is in fact applied, yes.
Yeah. And it should be, I think. Thanks. So that's me on the merits mainly.
Charlie?
Well, we didn't get enough it was just mentioned the necessity defense. Didn't really come into it enough, but then the question would have been, what are the terms of necessity defense, which are not set forth here, which vary, but largely present the same issue of proportionality, or could you do something else? And so it would be pretty much the same. The striking part of the record is that two treaty parties agree to amend a treaty that enters into force to preclude nationals of third countries to come in. Well, they didn't have any right, well, that's very interesting because there was a bilateral investment treaty between, is it Bespian and the
And Corellia.
and the respondent, yeah. Well, that raises very interesting questions as well, which obviously didn't come up here because they were not represented. Anyway,
I take it.
good job all around.
I take it, Christian, that you would have, with more time at your disposal in front of us, you would have pursued very, very clear alternatives
Yes.
that the state has. I mean, just as a matter of practice, I think that's what you would have had to do. I think you could have done it. It doesn't take a great deal of imagination
Right.
to think of ways in which the state could have accomplished its purpose without an absolute indefinite bar.
One of which would have been, although we were kind of guided away from the facts on this, which is that even a virtual engagement with the authorities, because our client has not even been allowed to zoom in
Right.
to proceedings to protect its factory. So putting aside even the physical presence, which would have been our first line of
And the
alternatives.
authorities could have crossed the border to the investor state. Now, that
Yeah.
depends on the investor state policies on border crossing. But, in terms of communication, we don't really need to think only about remote, despite the fact that that's all we do these days. But there could have been in-person communication to the extent that the authorities would travel.
Right.
I'm just giving that as an example of a modality that you would have pursued. And I think you would want to tell us that you attempted to.
Yes,
You
although
wouldn't just say, at this stage, theoretically, you could have been less drastic. I mean, I think in the course of this dispute, I suspect you would have proposed those.
Yes, I was thinking if we'd had exactly this case 2 years ago, perhaps you'd have been a lot less sympathetic to those needs. Now we're weathered to those alternative measures. I think it's a new framing for us.
May I ask you, as a matter of practice, just a genuine question, how far would you have gone during the entire argument in this case in laying out all the things that the state could have done?
Significantly.
I take it that would have been
Yeah,
a major part of you.
absolutely, because I would wanted to have offered you a spectrum, and then I would position respondent state at one extreme end.
That would be the best pathway,
Right.
and highly advisable, and I know you do it. You just didn't have time to do
No.
it for us.
But
well,
Natalie then would have been able to do more with Philip Morris, I think, which is, in Philip Morris, there's all this evidence, and they say in the facts that DART 19 is poorly understood, but very, very dangerous, almost like SARS, it sounded like to me, so that more drastic remedies, and even saying indefinitely, as in we don't know when we'll change this.
Right.
Would have
Indefinite in this
been
case didn't mean forever. It just
justifiable.
means you're facing a pandemic of uncertain duration. Yeah.
Hugh, I don't know in the past whether we've had audience questions. I believe we have, or
Yeah.
comments.
We have on our schedule that, like good
There it
tribunals,
is.
we follow
So we're going to follow our schedule, even though
from our
we
hosts.
didn't.
No, we're just a
We're
little
not,
off.
just a little bit off.
We're
So
supposed
why don't we have commentary?
Yeah, questions, commentary,
Commentary,
self-defense up on the podium.
Two questions for Natalie. One, you indicated that you might have, had you been in the investor's shoes, you might have used the MFN clause in your argument, and I'm wondering what you had in mind. And my second question is, when you look at the measures for DART 19, no one raised the precaution principle, right? This idea that because it's so unknown and it's so dangerous, you're allowed to go a little broader than you might otherwise because of the unknown nature of it. And I'm curious why that didn't come up.
So on the MFN, it was really, frankly, kind of going back to my moot court days, when you have a fact pattern that gives you only so few tags that you can go after. One of the few things that we saw in the fact pattern was that in the choice between the Praelium, the Alderaan bit and the Bespin bit, is the Alderaan bit had an MFN clause and the Bespin bit didn't. So recognizing that there would be difficulty with this argument, whether or not sort of the argument could be made that really to fully understand whether there are investment protections that are available, you should take into account whether there's an MFN clause that would allow you to get other investment protections. That was just the question there. And then on the precautionary principle, I think this is sort of what Lucy's argument was, or observation was getting to, that yet another tag that we had in the fact pattern that I could have made more of, had the clock been on either one of our sides, would be, yes, again, we know very little about this disease. We know very little about how long it's going to last. One of the few things we know is that if you restrict the people who come in, you have a better chance of restricting its spread. Yeah.
Other questions?
I'll comment.
Comments? Better arguments?
Great.
So I suppose this is a question for Christian, or maybe
I
for
don't think that's on.
a question, I guess, for Christian or also for the members of the tribunal. But we got to proportionality arguments kind of at the second step in response to necessity. And when I was listening to Christian talk about the right of access that was subject to me, that was a natural sort of qualified rights analysis. Got it from human rights law, say, take you naturally to a proportionality analysis. The right exists but can be subject to restrictions, proportionality. I'm wondering, Christian, whether you thought of getting into proportionality earlier and reaction to whether that would have been a helpful.
No, I agree with you at that. The problem is the first step is such a treacherous place for me, which is the public health right and the police power. And that's what I was scared of. And I thought that Natalie would be jumping on my head about Philip Morris and the police power. And of course she did to a certain extent that time permitted. So I did want to delay proportionality. The issue I wanted to deal with first was try to spend some time bringing the economic factors as a consideration for public health policy considerations, to try to sort of, to use the cake analogy, to bake it in to the fact the executive order already thought about economic considerations, and therefore it was arbitrary. So arbitrary for me was the first line, and then proportionality was something I thought would come second.
I also think, from my point of view, even though, as I said, I'm very responsive to proportionality arguments, it's viewed by many as that's what you argue if you have little else, if you know what I mean. And I think that is perhaps what was going on here. Christian, that's consistent with what you said.
Yes, exactly.
Proportionality, a proportionality argument can always be made. Now, sometimes it's convincing and sometimes it's not convincing. But the idea of exploiting other avenues before getting to proportionality, despite my attachment to it, I think is a very good idea. So the postponement, so to speak, made sense to me.
Right.
I think that's
Yeah, it sometimes feels like unlike in a municipal law, a good faith argument. You sort of throw it in as a catch-all attempt to clean up.
You always put your killer arguments before your squishy ones.
Yeah, that's another way of putting it.
Okay?
Got a question here and here and there.
Thank you. A question about George's point about dual nationality and effective nationality. I'm just wondering if you had more time to deal with his very smart remark about burden of proof and implication that it shifts or doesn't, how you would have dealt with it. Because I had a feeling that, Natalie, you were saying, well, it's ours a little bit until we cause doubt, and then it's Christian's. Whereas I suspect the Christian would say, no, it's yours. You're saying jurisdiction, you're taking away, my case. So I wonder what you would have said there and whether you would have talked about inconsistent practice of past tribunals and ICJ in treating effective nationality to say, well, we don't know what we would have gotten from an alternative tribunal. So just wondering how you would have addressed burden shifting and also the merits of the argument in your presentation.
If this were a real case, there would have been a lot more facts to play with than we ultimately had, right? Because on its face, this part of the question, I think, was designed, frankly, to be an easier lift for the state than for sort of the merits argument. So faced with that, you would have sort of tried to throw as much doubt in there as possible. So George's question, sort of like, how do we know that it's actually available?
That's right.
As you can tell, I mean, my response is, because that's all we know.
Exactly.
the record
but as
doesn't
soon
tell
as
us
you look-
anything else.
As soon as you look at this problem and you see dual national, you know there's territory to go down,
Right.
as some of my students know. Is it dominant nationality? How much do we have to establish about access to the alternative forum? If this were fully developed case that we had an opportunity to have, that would have been unpacked.
I
think
agree.
it would have to.
So
have been.
I think the state would have had to tackle it. The arguments boiled down would probably end up in the same place, which is why it's an easier lift for the state, which is, the contracting parties here, including one of his home states, thought about this, and they, sort of made a deliberate choice. Everybody knows that there's a menu of options, and what they're saying is, you only get to this one if this is your only choice. So while I would have had to develop responses, I probably would have ended up in the same place.
Yeah, no, I think I'm kicking myself now, having not responded more on that point out of the interest of time, to exploit exactly the tribunal's uncertainty, which is, you're absolutely right, you don't know, and neither do you have to inquire. But that's the uncertainty out there. And
Well, I would have.
because you've just
No,
ruled,
I would
Professor
press
Bermann,
this
no
more,
recovery.
as you might imagine. Because access, to me, availability does, I think it's a strong argument that it's not available because you're not considered to have the right nationality. That is a jurisdictional issue. I think that's stronger than saying, I won't get the same protection. You see what I mean? I won't get the same protection. This didn't work for me. But if, in fact, the treatment of the dual nationality issue kept you from invoking a treaty because you don't have the dominant nationality, or whatever the test may be, that goes to availability, to my mind. And so it's very germane. So,
Lots of hands going up now. I think there were two here, and then one over there, then.
So,
Over here.
yeah. So my question would essentially rotate around jurisdiction and more specifically expropriation, because I believe the investor has also moved for violation of expropriation. So with bearing that in mind, wouldn't that mean that the tribunal would lack jurisdiction under Article 1.3? Because then the investor would be able to avail himself of an investment protection under the Bermann Corellia BIT as well.
So, yeah, that's state's argument, I think, which is, if I've got expropriation, then that's a protection that's available under the Bermann-Corellia Treaty. Then go to the Bermann-Corellia Treaty. That's essentially what state is arguing.
Yes, but sorry.
Please.
But what was argued was also from an FET standpoint, and expropriation was not given because it was coming into conflict with the other BIT as well.
Yeah, we assumed, I think, I can't remember if it's explicit, but we assumed that there's expropriation rights under both the Bermann-Corellia and the Alderaan-Corellia Treaty. So that would have I would have had to have conceded that is an investment protection that is not available because it is able to be availed of under the Bermann-Corellia Treaty. The asymmetry is with FET. I can only get it under the Alderaan-Corellia Treaty.
and I would say too bad.
Exactly, I've heard that.
So I would say that picking up on what Natalie said, this clause is really a last port clause. It's your government saying, we recognize you have a right to somewhere. If it's not us, it's somewhere else. And I would have developed that. probably a bit more on the FET, finding an equivalent protection. If we had more than 1 hour, we could have done a lot. Other questions? I know there are
There were
some.
lots.
Yeah. There you go.
First of all, well done to both of you. You're long overdue your round of applause, so I'll be very brief. Question for both of you, not to play favorites. For Christian, I think the difficult part of your argument is that they're able to avail themselves of, and you're saying, well, it should be sort of de facto analysis, am I actually able to avail myself, whereas you could argue it's a de jure analysis, are there protections out there? So you could think of it, applying the MFN type, does the existence of a treaty count to trigger the MFN clause, or do you have to have actual treatment? And then how far would you go? What if there were an FET provision in the other treaty, but it had, say, a statute of limitations or something, a prescription period, and by negligence your client didn't pursue that claim? So if you take your de facto argument to the extreme, I think it gets very difficult for you. And then Natalie, for you, on the Article 13A, the Bespian citizenship, isn't it problematic for you, the Lockerbie principle, that it comes after the case has already started? So if it had been an interpretation or a declaration or an amendment to the treaty before the case had been commenced, that would be one thing. But what do you do with the Lockerbie principle, given it comes after the treaty?
So it's retroactivity in spades, right?
Well, yes.
Yeah,
It's sort of
so-
as in events subsequent to the saisine can't deprive a tribunal of jurisdiction. So I had trouble with it's a separate, and it could be a separate and independent had it come before, but I don't think it can be separate and independent when it comes after, given Lockerbie.
That was one in which I will confess I took advantage of the ticking clock and I read the room. The tribunal, I had no questions on it. They weren't going to press me on it. I wasn't going to get into the fancy dancing that I was going to have to do in order to make that argument. I did have responses, but if they weren't pressing me on it, I wasn't going to open it up.
And it's a good point, the de jure point, but the problem is with the fact pattern, we don't know what is legally available under the Bespian-Carrillo Treaty. So it would have been good in the sense I could have thrown it in that, look, I'm not even getting access to a municipal remedy.
Right.
Look, what is available? But the problem is able to avail is actually looking at the Bespian Treaty, not the Elder and Carrillo Treaty.
What if you had MST under one and FET under? I mean, it could, that pattern could have been more difficult for you on that one, but.
And then there was
Lucky it wasn't.
There's another hand.
Yeah. Well, I need to do that in order to apply my treaty. I mean, it's unavoidable in my judgment. I'm not interpreting or applying the other treaty for the sake of it. I am trying to give meaning to availability under my treaty, and that would be the pathway I would take, and I think you would not be surprised if that were done.
Right.
So I don't think I'm exceeding my mandate, if that's the suggestion, by interpreting a treaty that is not before me when that treaty is implicated by the terms of my treaty.
Right. It may depend on how far you have to go. I mean, if there are open questions under the other treaty about whether dual nationals or not, would qualify under that treaty, it's interesting, how definitive a decision would you make? Or
and we would be
are there-
speculating, perhaps. We would have to talk about the precedent under that treaty and what the dominant view of tribunals have been with respect to dual nationals. But for me, as I said a moment ago, that goes to the availability question so directly that I would go down that route.
Any other questions? Over there.
Great job, first of all. And building on what Mark said, and partly, I guess, what Ina also said. If you consider whether or not you're able to avail yourself of an investment protection, let's say expropriation, you don't meet the threshold for expropriation, and you would meet the threshold for FET. So let's say you bring a claim under the Bermann Treaty, and you fail because the tribunal says there isn't expropriation. Would you then be able to pursue a claim under the Aldrin Treaty? And so going to Mark's question, in addition to the question of dual nationality, do you have to assess whether or not it meets the threshold of expropriation or whatever investment protection is available under that other treaty? Because if you fail that standard, then you're unable to avail yourself of an investment treaty protection, in which case maybe you revert to the Aldrin Treaty. So as a
I don't
practical
think
matter,
you have to win in order to avail yourself.
well, if you're unable,
That's 'cause you're the
if you
arbitrator.
lose, then you're. Well, I think that's a question though, because if you lose, then I would say you're unable to avail yourself of the protection. Under the
Oh,
treaty.
well, I think we differ there.
But in any event, as a practical
right of
matter, I
appeal.
think wouldn't you just bring the claim under both treaties and see and if you prescribe to my interpretation, which obviously if George disagrees with you, you should not prescribe to my interpretation. Ascribe to my interpretation. But if you do, then you would just bring it under both. If you win on expropriation, you win on expropriation. If you lose on expropriation, then you have the other treaty.
I love this argument because it gives me an appeal, essentially. So I'll run to Bermann, Praelium, and when I don't win, I'll say, you see, I was unable to avail myself. You have to hear me.
That'll be 10 years from now, though, and we'll have vaccines.
You'd be a
We'll
lot
have
better off
vaccines.
with that line of argument. But I wouldn't allow it
Pick your arbitrator wisely.
if I were the arbitrator.
I see a question in the front row here, Kathleen. Kathleen.
So is what sort of boiling this all down is, George, is what you're saying that fundamentally able to avail means it needs to be a jurisdictional argument. And if it's an argument on the merits, because that's what having spent a little time in The Hague, the dual nationality thing to me was that's the argument, because that's a jurisdictional
That's
argument.
essential. The nationality issue is essential to availability. There's no
So-
question that that's jurisdictional. But I think, Raheem, I could see your point, but to me, availing yourself means having access, having the possibility of making a claim. I think to expect that you have to win in order to be able to avail yourself is over-reading the term avail.
But if I can't avail
have to
myself
win
of
on
FET, you
Yeah.
discard that.
Exactly.
I can't change him until it's in print. There's no render of an order.
All right. I think we'll have a formal, someone else will speak, but just on behalf of our tribunal, I want to say a few things. One is David, Caron would have loved this. And I'm very grateful for Susan,
thank you.
for coming. Thank you. And if I could sing like David could sing to his students, I would, but I'm going to save you from it. So I want to thank Natalie and Christian for being very agile and good-humored and well-prepared advocates, giving the questions that you had to field, and of course to George and Charlie, who probably aren't going to forgive me for stopping them, and to Columbia and Kings and Three Crowns, of course. So thank you all.
Where's Sophie? Oh, good.
Good evening, everyone. I'm Sophie Emberson. I am the Business Development Coordinator at Three Crowns. Just like to say thank you all so much for joining us, both in person and virtually. It's so lovely to see so many people in a room again. I'd also like to say thank you, of course, to our esteemed panel, to our tribunal, Judge Charles Brower, Lucy Reid, and Professor George Bermann, and of course to our advocates. It may have gone better for some of you this evening, but Christian Leathley and Natalie Reid. So I'd now like to invite you all to join us for a drinks reception with hors d'oeuvres through the back doors, and I hope you have a lovely evening.
Thank you.
Thanks very much.